Hello, everybody.
Kimberly McLaren.
Okay.
She's broker.
She's broker. Is she in the Zoom?
Yes.
Okay. Ms. McLaren, can you hear me?
Yes, I can.
You have, oh, there you are. This is file 253081 SD, people of the state of Michigan versus Kimberly McLaren. Appearance, please, Mr. Villar.
Good afternoon, Your Honor. Mike Villar on behalf of the people.
Thank you. And Ms. McLaren, please state your name too, ma'am. Uh-oh. Can't really hear you very well, Ms. McLaren. It may be that you have to turn your video off, and then the audio might work better.
Yeah, it's not even letting me turn my video off. There we go. Can you hear me?
I can. Can you hear me?
Yep.
Okay. If this gets too choppy, just let me know and we'll try to work something out.
Okay.
So, Ms. McLaren, today is the date and time set for sentencing in reference to failure to stop at a property damage accident. You pled guilty to this offense, and that was, I believe, on September 23. 1 second. Yep, September 23, the court accepted your plea. At that time, you had Attorney McCain. Do you still have a public defender, or are you
No.
representing yourself?
I don't.
Okay.
Yeah.
Okay. For sentencing, Mr. Villar.
Thank you, Your Honor. I think in this case, the defendant took responsibility for actions by pleading guilty at the arraignment. So we do appreciate that. However, there was an incident where the running board for a gentleman who was just parked got ripped off, and a witness saw the defendant look at the vehicle and then get back in her car and leave. So I think that she should be aware that anytime there is an accident like that, she needs to leave she needs to contact the police, and at the very least leave her name and number for the person whose vehicle she damaged. Instead, she had to be discovered. So I think that mitigates against her. I think that she doesn't have a bad driving record. This is something that seems like an anomaly. However, I think it was a bad choice by her. And I think that there may be some restitution for the vehicle, but I think that my understanding is that insurance has covered that. So I guess I would ask the court leave open restitution for us to claim if we get notice of that.
Okay. Thank you, Mr. Villar. Ms. McLaren, what is it that you think that the court should be aware of? And what do you think the court should do on this case?
So I did not leave. It was in a parking lot at a football game with 4 different schools. So I did pull out because I'm like, I can't fit in this space. So I did move. I had no idea who the vehicle belonged to. It started raining. So I didn't put a note on the car because it was downpouring. They actually like canceled the football game, like, because it started thundering and lightning and everything. And I had no idea like who to even begin to look for, like who it belonged to. There was no one announcing, so we couldn't even announce it over the PA system. But absolutely, I'm at fault. I know that I should have left a note, but I just didn't think a note was going to do any good because it was raining. I didn't know I was supposed to call the police because it was private property. But no, I mean, I own it. It was a mistake, and that's pretty much the gist of it.
Okay. Well, let's go back to that night. It's raining, you're at a football game, and you realize that you've damaged somebody else's car. What would you do differently next time?
Call the police.
Okay, yep. Definitely call the police and sit in your car, right? If it's raining, and you're leaving because it's raining, right? The other car, the occupants will probably be going to their car real soon, right?
Yeah,
right?
possibly, yes.
Because they canceled the game, so everybody's leaving. you gotta figure that those people will be leaving soon also.
So they just postponed it. They were gonna restart it once the rain stopped, but I had to go pick up another child from somewhere else. So I just left and I just told my son, call me when the game's done and I'll come back and get you. So that was part of the other reason I didn't just sit there and stay. So just a little other piece of it. So, but
you also have to know that in this day and age, there's either a security camera or somebody with a phone watching you, regardless of what you're doing, right?
Sure.
And so something like that, somebody's gonna be saying, "No, yeah, I saw this car hit this other car," and like Mr. Villar was saying, it goes from bad to worse, right? It goes from something where you can apologize and say, "Oh man, these cars sure were parked in here tight, and I got distracted, and I'm very apologetic," to a misdemeanor where you could go to jail and place on probation. Right? And if this was your car or if it was one of your kids' cars and somebody damaged it, you'd be pretty upset about that as well.
Yeah, absolutely.
Okay. Well, and I understand running kids around and getting distracted by all that stuff, but at the end of the day, this is on you. And I do appreciate you taking the accountability right out of the gate at the prelim. So the court will utilize fines and costs, and those fines are $200 fine, state costs of $50, other court costs of $300, and a crime victim right fee is $75. All in, that's $625. That will be due within 60 days. If you need additional time, contact the district court. They'll work with you. Just make sure that you follow up with them and you're making some payments. Okay.
Okay.
If there is restitution down the road, Mr. Villar's office has the opportunity to file a motion. Okay. That doesn't mean that if he says it's worth $15,000, that doesn't mean that that's what you're going to be ordered. That means that there will be a hearing on it, though.
Okay, I understand.
Okay. Can I get a phone number from you, please, Ms. McLaren?
Yeah, it's 269.
Okay. Well, thank you for being accountable, Ms. McLaren, and I can feel very confident that you would be doing things differently next time, right?
Absolutely.
All right.
Let's just hope there's not another next time.
Well, I hope so too. That's the whole goal. Anything additional, Mr. Villar?
Nothing, Your Honor.
Thank you. Good luck to you, ma'am.
Thank you.
Next case, Michael Reisner, and bring in Mr. Richardson in. I do not know if his client is with you.
He's just on standby. Good afternoon, Your Honor.
Good afternoon.
Hey, Mike, I sent this. I've been working with John on this case. I can send you the email if John's out of the office today. He paid restitution.
Judge, let's call the case.
Yep. Let me call the case. It's 2523577. Sound People of the State of Michigan versus Michael Joe Reisner. If we have appearances starting with Mr. Villar.
Good afternoon, Your Honor. Mike Villar on behalf of the people.
Good afternoon, Your Honor. Kurt Richardson for Michael Reisner.
Thank you. Is your client available, Mr. Richardson?
I can have him call in if you'd like. He's older and he called in on the phone last time. I essentially, we had worked out an agreement where he paid the restitution and that was paid this morning. I emailed proof over and we were hoping just to give prosecuting attorney's office just a little bit more time to verify. And then they were going to issue a dismissal.
Okay, the court does have, Mr. Villar, I don't know if you have this as well. The court was just provided an email from Mr. Richardson indicating that restitution had been paid in the amount of $222.76 to Walmart on behalf of Michael Reisner And the email chain seems to imply that there'd be a dismissal upon payment of restitution. Is that your understanding, Mr. Villar?
That is the agreement that was reached. I do not have proof of the restitution at this point. Mr. Richardson may have sent it, but if I would point out that the agreement was made back on September 12th. And so there's been quite a while to get the restitution covered, and to get it just done this morning is a little worrisome. But I think if he's made the restitution payment, then we have agreed to dismiss the charge.
I just emailed it to you, Mike, and essentially what happened was he furnished the check to the court and the court wouldn't accept it. And so then we had to redo the entire check directly to Walmart, the victim. And so that's what the delay was.
All right. That all being said, will your office be preparing a nollie? Or you want a nollie to be prepared? Then, Mr. Villar, we can prepare the nollie.
So I'm looking at the email that I got from Mr. Richardson. Shows it looks like a cashier's check made out to Walmart on 10/22, and then I think Kristen Whitney?
Yeah.
Of Mr. Richardson's office received this check on behalf of Walmart on November 4th of 2025. So I don't think Walmart has actually received it yet. That'd be my understanding from what I see here. Is that your understanding, Kurt?
They received it this morning.
Okay. Someone from your office gave it to them?
My staff hand delivered it this morning and got a receipt.
All right. Based on Mr. Richardson's representation, we will issue a nollie.
We can print that off, Mr. Villar, if you're comfortable with that.
Yeah, that's fine. That would be fine. So we do not have to do a nollie?
No, we'll do it. Had your client been present, Mr. Richardson, the court would just remind him of not having sticky fingers. The ticket that was originally authorized way back on July says that in the remarks section that he's done this multiple times. And as an individual who was born in September of 1953, he obviously should know better and behave a little bit better. So if you could just remind him of that, please.
Absolutely, Your Honor.
Okay. And the court does have a nollie here indicating that retail fraud third degree is being dismissed. And one other thing that you can point out to Mr. Reisner is that if this were to happen again, I imagine that the resolution will not be quite as favorable for him as this one was.
Absolutely.
All right. Anything additional, Mr. Villar or Mr. Richardson?
Nothing, Your Honor.
No, Your Honor.
Be safe, be well, sleep sweet, and much love.